Hello again. I'm Dr. Hung Vu, and our show is America's Healthcare Crisis. The topic of discussion for our program tonight is medicine and the law. I personally cannot think of too many other subjects that are more important than this one. As I see it, the doctors might save lives, but it's the attorneys who will determine what kind of life is going to be. So I'm privileged to have on our panel tonight 4 prominent attorneys practicing in our community, 2 of whom are also physicians. Our first speaker is Dr. David Rupsaman. Hello, welcome to our show.
Thank you.
Dr. Rupsaman is the renowned editor of the Professional Liability newsletter. And I have been reading his newsletter for many years now, and I'm thrilled to have him here with us tonight. Welcome to our show. Thank you for being here. Mr. John Tyndall, JD, is an attorney practicing in San Jose. He specializes in representing the plaintiff in medical malpractice cases. And he belongs to several professional associations, among which are the American Society of Law and Medicine, and also the American and Californian Trial Lawyers Association. He has been a guest on the McNeil-Lehrer show before, and he also has a special interest in the toxic contamination subject. And I'm very privileged to announce his presence here tonight.
Thank you, Doug.
Thank you for coming to share with us your knowledge tonight. Our first speaker is Dr. Marvin Firestone, MD, JD. Dr. Firestone is a practicing psychiatrist in Half Moon Bay, and is currently the president-elect of the American College of Legal Medicine. Welcome to our show.
Thank you.
Thank you for coming. Mr. Norman Salcido, JD, is an attorney practicing also in San Jose, and also specializes in representing plaintiffs in malpractice cases. We also have a live audience with us tonight. Some of them are physicians and health professionals. They are a selective and thoughtful group, and I welcome them to be here with us tonight also. So without any further ado, let's talk about medical malpractice. Dr. Rupsaman, can you give us a brief summary as to how, where, and when medical malpractice started in our country?
Well, I think that California was the lead state. And in California, prior to the middle 1960s, medical malpractice was really not such a much. In fact, prior to 1958, 59, it was virtually non-existent. There weren't more than 2 or 3 attorneys in California with even bringing medical malpractice suits. And there was a reason. The reason was that in proving a scientific case, and medicine, after all, is a science, the attorney representing the injured party, whom we call the plaintiff, the attorney for the plaintiff has to have an expert witness to sit in the witness chair, point the finger at a colleague and say, his conduct was negligent, his conduct caused this injury, both substandard care, in other words, and causation. Physicians just weren't willing to testify against colleagues prior to the middle 1960s. By that time, there were a few who came along. I would say by the early 1970s, 71 or 72, in almost any valid medical malpractice case handled by a knowledgeable attorney, there would be an expert witness, that is, a physician willing to testify for the attorney. By 1975, 1980, the number of available witnesses were really quite numerous. Originally, they came from the university, because the university doctors didn't feel the collegiality with the community physician, so they were less inclined to refuse. But it was very likely that if you had a Northern California case, it would be a physician from UCLA or USC. And if you had a Southern California case, it would be a physician from Stanford or Cal, for example. That seemed to be the routine. But by, I would say, certainly the mid-70s or so, community physicians were quite readily available. Still a minority of physicians. Most of them still to this day would much rather not go to court and really will not testify for either side, but especially for the plaintiff. But still there are enough to supply the necessary expert testimony in valid cases. I think there were two major hallmarks, let's say, in the development of malpractice in California. And I would say the first was the Medical Insurance Compensation Reform Act of 1975. And that act was one which put a lid on damages for the patient, so-called general damages, i.e. pain and suffering, and other elements of the tort reform which tended to reduce losses. So that California went from being the first or second state in the union with regard to malpractice premiums charged doctors, down to, at the present time, maybe 15th or 20th. So the tort reform has been enormously effective. Now I think the other element in California that's been sort of a hallmark really has been a series of cases beginning in 1972 with Cobbs versus Grant, our informed consent case from our California Supreme Court, that says the doctor has got to talk with patients, explain risks, and let the patient understand what's going on. Growing from that has been a series of events we don't need to go into right now, which have made, I think, the doctor more conscious of his responsibilities to the patient. And I think in 1993, we really have a group of physicians who are closer and more, well, more physician-like, if you like, to our patients than perhaps 30 years ago. This may be contrary to some observations in California, but I see that, and I see it especially as compared to medicine on the East Coast, where the patients are very much still the passive recipients of the doctor's skill, are not taught to very much, and are placed in a somewhat different position there in California. Dr. Firestone might comment on that since he was a professor at GW
right.
for a time.
So maybe you can give us an idea about the evolution of the malpractice situation from its inception, like in the late 60s until now. Has it got worse, better, same?
Well, I think there have been several factors that have led to some greater pressure on physicians as a result of the malpractice, I'll put crisis in quotes, because it's difficult to determine who is in crisis, the physicians or the patients or the insurance companies. But in any case, with the passage of the Healthcare Quality Improvement Act in 1986, which evolved to a situation where a national practitioner data bank has been developed, and greater pressure on hospitals under the doctrine of corporate liability, this puts even greater pressure on physicians because if, in fact, they lose their hospital staff privileges, they eventually probably will end up losing their license. And with the hospitals being the defendant in many cases where physicians may have not had adequate insurance coverage, hospitals became, I think, very an advocate of the physician by essentially taking a greater hand in weeding out incompetent physicians, and if they were very much of an advocate. A lot of physicians would lose their privileges even if they were not incompetent. So the physician was feeling the crisis not only from premiums, but also a great deal of pressure in maintaining his hospital staff privileges. And I think this, with the National Practitioner Data Bank as a threat, I think puts greater pressure on the physician in his practice. And I think that this has been a problem and added to this crisis in healthcare.
Let's talk about MICRA a second here. Dr. Rob Summon mentioned earlier, MICRA stands for Medical Injury Compensation Reform Act. It has to do with limiting the amount of awards given to the plaintiff or the patients, and also limiting the fees of the plaintiff attorneys. I have here with me this little brochure here that is published by the Californian Allied for Patient Protection. I don't know if you're aware of this, but according to this publication here, MICRA is good for everybody except the lawyers. So I'd like to hear from one of you, Mr. Tyndall or Mr. Salcido. You want to comment on this?
I've not seen that publication, nor when we got together earlier this evening did you share it with us. But in regard to MICRA and the patient, I think MICRA has just had a devastating effect on what a patient can do in the way of being compensated for somebody who negligently causes a catastrophic injury, if not death, what kind of evidence can be brought forward, what the judge has to do to a verdict if the patient is successful in proving to the jury that he or she does deserve compensation. And in almost all other respects, I think MICRA is just a disaster for patients.
My understanding is that it does not limit the compensation for economic losses. You can have as much as you deserve to have if the injury that you incur, that is inflicted upon you, causes losses in economic earnings. And the only limitation is really in the areas of pain and suffering, and also the compensation for the attorneys. And just wondering, I mean, like, why is that the plaintiff attorneys for a long time wanted 40% of the award? Why not 10%?
Well, I think you've got it backwards in regard to the compensation for attorneys. In fact, I think you will discover that most attorneys who represent plaintiffs in personal injury cases, like automobile accident cases or industrial injuries or things like that, they generally get a fee of about a third if they're successful in what the trial result is. In MICRA, for the first $50,000 of recovery, after the costs are deducted, the fee is 40%.
Right.
So that's more onerous on the patient. And then the fee for the next $50,000 is a third. So that's certainly, if you look at it comparatively to other tort situations and other personal injury suits, that doesn't help the patient from your logic.
But what I'm seeing is that there's difficulty measuring the amount of pain and suffering. This is a subjective kind of situation.
That's the second problem with your approach, in that we discussed a little earlier about the patient that I represented who was made completely blind at a very young age. There wasn't much in the way of any earnings because the person hadn't started earning anything. So the economic damages themselves weren't much, and also the patient belonged to a big clinic situation, so that the health care problems in the future would be taken care of. But aside from the blindness, the patient was perfectly healthy. That patient had a life expectancy of another 50 or 60 years, was going to spend all of that time entirely, totally blind. They would be limited in California, because it was a medical malpractice case, to $250,000. If that person had been blinded by a truck or a train or any other professional who wasn't a doctor, there would be no such limit. It's very, very unfair.
Yeah. I guess the thought I have is that certainly under certain circumstances, individual circumstances, certain patients may lose out, but the whole concept of MICRA was created because the malpractice in medicine, has created such a crisis. I mean, within 5 years or so.
If you were here in 1975, you would have known that that crisis was manufactured, was fraudulent. Essentially, the medical profession, which was a very closed society, which had the most powerful lobbying group in the state, the California Medical Association, scared the legislature into passing it. And at that time, and I know I worked in a big law firm that defended most of the hospitals in the Bay Area and most of the doctors, many of the doctors, we never thought it would be held constitutional. But there was no real crisis. It was manufactured to protect the doctors.
I have to disagree with you, John. I think there was this problem. Among physicians generally, the premiums really were quite high. I'm not thinking of the premiums charged by the commercial carriers. I'm thinking of the premiums charged by the doctor-owned carriers, which came into being in late '75 and in '76. And their premiums were really quite substantial. The effect of MICRA has been to hold down those premiums. As I said, compared to the rest of the country, we're down below the 15th highest state, 15 to 20 right now. And I think that's an important feature, especially for physicians practicing in rural areas who really can't afford the astronomical fees that are charged for insurance in the top 4 or 5 states.
But if you break that down, David, I think that you'll agree with me that it doesn't sort out that way. As you yourself know, now in many rural areas, doctors are going bare anyway because they say they can't afford it, or many of the specialties are. And the specialties which were claiming the most need for protection from the rising medical healthcare insurance premiums were the neurosurgeons, were the obstetrician gynecologists, and were the anesthesiologists. And that's because they were doing the most human damage to people at that time in an overwhelmingly catastrophic way. Furthermore, when you broke down what they were making and what they were going to be charged, they were all still netting $300,000 or $400,000 a year. I mean, their lifestyle wasn't getting cramped, and nothing's really changed. The only thing that's changed is that the patient in California comes out on the short end, and in this particular area, in a medical malpractice case, cannot recover what anyone else in any other kind of lawsuit could for the same injury, and that's unfair.
Let me ask you, how often does that situation of the blind patient you're talking about, how often does it happen? I mean, statistically, I understand that up to 80–90% of the cases are thrown out of court anyway. They have no trial. So how many cases, per year or throughout the whole history of malpractice do you have situation, that you just mentioned as an example? I mean, are they frequent? Because what I'm trying to say is that we have to sacrifice somehow the benefits to certain individuals to save the whole picture here. Because I have the graph here on here. In Ohio, when it started out with MICRA, the liability went down. And then when I repealed it, it went right back up. So what Dr. Robsamen was saying was that he was supporting this data right here. In other words, the malpractice situation can go out of hand without a MICRA. That's my understanding. Mr. Saucedo, you want to mention something about that?
Well, you talk about the number of cases, how many cases. I can't quote statistics, but if it happens to one person and it's you, it's a catastrophe. The cases are legion. You're talking about cases where the doctor takes out the wrong kidney, takes out the healthy kidney. Person is on dialysis for the rest of their life, $250,000 because the person's retired. Doctor amputates the wrong leg, $250,000. So the cases are there. The plaintiff's attorneys...
That's the pain and suffering though, because there's no limits to the economic loss. If I lose my leg, I may gain more than $250,000.
But not if you're retired.
But not if you're retired.
Norman's point was if you're retired, then you have no economic loss. If you have health insurance coverage, then you're out there too. So that Norman's right about that problem.
I think you also have to understand that you may have a misunderstanding with regards to the settlement versus going to trial. The same laws or statutes that affect the damages at trial are going to influence what the plaintiff is willing to settle for, because of course the defendant is not going to pay any more than they would otherwise have to pay if the plaintiff went to court. So just because they're settlements doesn't mean that they're not settling for less than the value of their case, and I think that's the point that the attorney
You also have
made.
to understand that not all plaintiffs' lawyers are against MICRA. MICRA is good and bad. The good part is, for example, the periodic payments. Let's talk about the economic loss. Let's say a person is 30 years old, can't work anymore because he's a quadriplegic from whatever it is. That person will be paid his wage loss for the rest of his life. But they're not going to give that, and that wage loss may be, in terms of its present value, let's say $1,200,000. Well, that person doesn't get the $1,200,000 in a lump sum. That will be paid, apportioned over that person's lifetime. That's better, I think, because people at times have a tendency to, if they get a lump sum, let's say a quadriplegic, they have guilt. They're guilt-ridden because they've put a lot of pressure on the family. They want to make up for what they've caused the family in terms of suffering, looking at him in the bed, can't move, poor dad. And so when dad gets the money, he buys a new house, he buys his 2 sons a new car, he buys his wife a diamond ring, and in 5 years, that $1,200,000 is gone. The way it is now, that person, that family, he'll get $10,000 a month until that $1,200,000 is spent. That's better for the plaintiff. But to say that $250,000, which was the sum of MICRA in 1975, is adequate in present-day dollars, to me, it's a totally inadequate sum of money.
And Norm, you have to add to your illustration, it isn't that the $1.2 million is divided up into aliquots. The earning power of that money, the person also receives. So the theory is that when it's set up on a periodic payment, it'll last for their entire life.
But the judge has the power to review that and adjust it one way or the other.
All right. Now let's move on to another aspect of the malpractice here, is that I am concerned about the fact that many physicians were indeed very good physicians, competent, knowledgeable, who just happen to have taken care of very sick patients. I'm talking about the professors in the universities, the surgeons. They have more of a risk of having malpractice because they're good doctors. They have to take care of very sick patients, the risk is higher. And whereas a doctor who is so-so, takes care of coughs and colds, may be totally shielded from that risk. And to me, that poses danger here, because eventually maybe nobody wants to take care of sick patients anymore because the risk is too high. One of the things that the surgeons usually say is that if you don't make any mistake, you haven't done enough cases. Because with the technology available to us, the risk is always there, and we cannot have perfection. And I'm afraid that the threat of malpractice has created such a anxiety in the whole community that in order to be fair to some individual cases, you can create a much larger damaging to the whole picture. Maybe you can talk to some of the audience here. Any of you have any experience with malpractice? And because it can really be devastating to the physician. And we're talking about a plaintiff patient here, which is fine, and the attorney who defends him is fine, but the big loser can be a good physician. What do you think? Anybody has any experience with that?
Yeah, I can relate my experience. I was on an ER call one night, called me at 2 o'clock in the morning. I came down to see a guy that was an extremis from sepsis, operated on him, he had a perforated appendix, and took care of that. And he died the next night. He was 60-some years old. I promptly got sued by the family, and And I spent the next year and a half talking to the lawyers, getting depositions and whatnot. I eventually was dismissed from the case, but of course it took 13, 14 months to do that. It probably cost my insurance company $30,000 or $40,000 to get me out of that case. And now I don't take ER call anymore.
You raise a very interesting point and a very important one. Anybody can sue anybody for anything is the old phrase. Now, if that particular case had gone to a really first-rate plaintiff's malpractice attorney, I would guess that he would not have accepted the case. Number one, the patient comes in with a perforated appendix, comes in with sepsis. This patient is destined, as far as a jury would be concerned, to have a bad outcome. The fatal outcome here is handwriting on the wall, so far as most juries would be concerned. Thinking of that prognostic point, most plaintiff's attorneys would say, I don't want the case. And if someone does take the case, the insurance carrier, which is just as sophisticated, would say, hey, we'll fight this all the way. We can win this one. So what you're really saying is, in our system, as we were discussing at your house earlier this evening, Dr. Fu, we really need a specialty board for a plaintiff's malpractice attorney, some sort of certification that says this fellow is first rate. Because I, in the past 30 years, have seen so many malpractice cases. And when I see a case which has really no value at all, I say to myself, why would anybody bring this suit? 99 out of 100 times, when I look at the name of the attorney, it's somebody I've never heard of. And we really have to get control of this situation by employing the screening talents of the good malpractice attorney, because the good malpractice attorney will reject 20 or 30 or 40 cases for every case that he takes, because he's not interested in wasting his money and his time on a case that is going to be fruitless. And I think this is a terribly important point, and I'm glad you raised it, because the issue is one that is too little addressed. And I think it has to be addressed first from the bar. Do you think the bar is interested in this, Norman, in this sort of reform?
I think it's going to be very difficult because I think Marvin brought up a good point. There are many lawyers who are extremely capable attorneys, trial lawyers, who can take a malpractice case maybe for the second, third time, and with good experts present a good case. I think the key sometimes in a case like yours is the expert who reviews the case initially for the attorney as to whether or not that expert is completely objective and is of the opinion whether the doctor was deviated from the standard of care. You have to understand one thing, lawyers don't set the standard of care, the physicians do. We have to get physicians that testify that this physician deviated from the standard of care of a reasonably prudent physician. In your case, I mean, I don't know anything about your case, but many times, just from the medical records, we can't make a decision as to whether or not a physician was negligent. Let's, take, for example, after the surgery, you leave an order for dopamine or, vital signs every 15 minutes. The order is there, the nurses don't carry it out. A nurse may say, well, I never saw this order wasn't written during my shift. It's the doctor's fault. So sometimes a doctor, unfortunately, has to be sued initially, and once the smoke clears, then the doctor can be dismissed. If the lawsuit is completely specious, then you have a cause of action against the attorney for malicious prosecution, and those lawsuits are very good because most people hate lawyers. And the biggest verdicts now are against lawyers rather than in many cases.
I personally am aware of situations when the
Physicians practice the state-of-the-art medicine, and yet once confronted with a malpractice case, he gives up. He doesn't want to go through the whole aggravation and trouble, and it can be devastating to a physician's career and his life. So he gives up. He says, well, let's negotiate, give them whatever they want. 30,000, 40,000 is the limit or something. And I think that it can create a situation when people just, cannot afford to go through the trouble. And you have a situation, like for example, let's talk about the data bank limit here. Because my feeling is that the malpractice situation creates such anxiety everywhere that I have been practicing. I have been in academic medicine, in private practice, in HMOs. And the physicians, either they hate the plaintiff lawyers or they are afraid of them. And the situation ends up being that they practice defensive medicine. They may spend 15 minutes with the patient, seeing a patient, say in urgent care or something. They spend 10 minutes or even 12 minutes writing charts. What they're really doing is they're treating their anxiety. They're treating peer reviewers. They're treating the malpractice lawyers who may be lurching at the door. They don't treat the patients anymore. You know what I mean? In other words, I'm very concerned about that because it has created such borderline paranoia in the medical community nowadays that the doctors don't concentrate on the patients anymore. That is why he missed things to begin with. And the fear is enormous. For example, let's talk about a data bank. Do you think that it has improved the quality of care or it has hampered it?
Well, I think the National Practitioner Data Bank has prevented the physician from perhaps having that mindset to settle the case. Mm-hmm. In fact, if there's any semblance wherein they might prevail, they're going to want to defend the case and go to trial, because even if they pay over $1 in settlement, the report of that case goes to the National Practitioner Data Bank in the great computer in the sky. So I don't think that the physician necessarily would be tending towards settlement as a result of the Healthcare Quality Improvement Act, National Practitioner Data Bank.
Well, obviously, such a measure is very helpful in preventing gross negligence or incompetence. But how often do we have that in this country, where the physicians are either completely incompetent or negligent?
Well, there's lots. And there was a recent article in the Wall Street Journal that one problem with the National Data Bank is doctors have very successfully caused lots of problems in one state and moved to another, or change either their incorporated status or whatever it is. So it's been very hard to really get any kind of uniformity or control over it. And we've read recently in our local California that the Board of Medical Quality Assurance in California was so evidently overburdened with complaints and work that they were just throwing them out or putting them in the trash can wholesale, so that for years nothing was being done. I mean, they're now advertising for people to turn in their complaints again.
Yeah. I'm aware of that. In other words, I think that for some time, like Dr. Upsaman had mentioned earlier.
But Norman and I know it very well, because you can mention certain names of certain physicians. And if Norman and I were having a drink, he'd probably look at me and say, "Who'd you kill this time?"
But you see, I'm afraid of a situation when you're really pushing the physicians to the wall, you know. And the latest data from Time magazine is that the expenditure for medical care has increased to 14% of GNP, among which is $100 billion are being spent for defensive medicine.
But Hawaii,
Where'd you get those statistics, Doctor?
Right here.
In Time magazine, 14% on defensive medicine?
No. GNP.
100 billion.
Oh,
But that's not. That has nothing to do with malpractice.
this has nothing to do with malpractice.
No, defensive medicine is one of the results of malpractice.
That's true. But defensive medicine often is better medicine.
I don't agree with
Doctor,
that
you
at all.
said, why should a doctor spend 15 minutes with his patient and then write good notes? Aren't you taught in medical school to write good notes and to listen to your patient?
Well, not that. If you think that writing good notes is that important, I don't necessarily agree that good notes always mean good medical care. I mean, anybody from high school can open a book and write the list of differential diagnoses to make a chart look good. But it may have nothing to do with the outcome or the care or the quality of care itself. And also,
if that patient goes to a new doctor and your notes are so bad in describing what's going on in the head, if that person had a subarachnoid hemorrhage or something like that, your notes weren't specific enough, the patient changes, the second doctor has no sense that there was a baseline initially, suddenly it's different, the patient goes on and is brain damaged.
Well, there's good defensive medicine and there's bad defensive medicine. Good defensive medicine is not necessarily writing a big note. Good defensive medicine is writing a concise note so that the doctor has a record that will aid in continuity of care for his next visit or for some consultant or another doctor if he should die after that visit. A good defensive medicine is where the doctor orders the tests he's supposed to order, not a whole battery of tests that are unnecessary. That's bad defensive medicine. So to a great extent, it may be a lack of education of the physician in how to defend and maintain a record that will defend him in a way that is in the best interest of the patient.
Yeah. Well, there are 2 points here. I agree with you in that I think there's good medical practice and there's defensive medical practice, the way I see it. In other words, the kind of practice you're talking about just makes common sense. You order the right test, you communicate with the patient, you take care of the patients. And if the records are so important, I believe that physicians have to be compensated for the time they spend documenting the charts. Because the lawyers work on the hour basis. The physicians work on the cases or the results. And also the trial lawyers have the tremendous advantage of the 20/20 hindsight. I mean, you go back to the chart, you see all the things wrong with it. But when you're on the front line, things may be very different. And I'm glad you're both MBJDs because, you know, I mean, you have taken care of patients who are very sick. And, you know, something goes awry. And then you look at the charts, you know, you see a lot of things wrong with it. You know, I mean, I don't know if it's totally fair because, you know, I mean, you have to be practicing in the front line, especially specialties like...
But in reality, though, I must say, although my work is entirely with doctors and hospitals when I do consult, I must say that the doctor who is held liable, there has to be proof he fell below a certain standard of care. And the reality is that in California and most states, juries tend to be sympathetic toward doctors rather than the contrary. And you've got to have a pretty strong case if you're the plaintiff's attorney going before a jury to prove a case. The insurance carriers know that, so they're not going to settle cases unless the negligence issue is reasonably clear. And in my newsletter a couple of years ago, I reviewed all of the cases I had written since 1968 when I started it. I'm in my 25th year of publication now. And I found that the great majority of time that when the jury verdict came in against the doctor, that it was either utterly justified or more probably than not justified. And a comparatively small percentage of the cases were probably unjustified. I found not one case that was clearly unjustified. I think the proof there is the burden of proof on the plaintiff is strong. But I'm very sympathetic with the point you raise about the psychological stress of simply being sued, as you described. This is the problem. The real problem is the experience of being sued regardless of whether you're negligent or not. That's the problem. And there has been one group that I studied for the National Commission on Malpractice in 1972. I studied the Ross-Lose Clinic, which had had arbitration, binding arbitration, as an alternative to jury trial ever since 1928. And of all the doctors I know, those doctors at Ross-Lose were the most cool, the most untroubled by the thought of being sued. Because if they were sued, the case would be arbitrated. It would not be a public trial. It would not be before a jury. It would be in privacy. It would not take 2 or 3 weeks. It would take 2 or 3 days. And Northern California Kaiser and Southern California Kaiser has used arbitration now for many years, and the doctors as a group really like it. So one way of getting around the problem of the anguish of being sued, I think, is to find some way of getting away from the jury trial and the spectacle of the trial and the length of the trial. That's what frightens the doctor when he thinks of the ultimate, you know, not settling the case but going before a jury.
You're touching on a very important subject here, that is the efficiency of the legal system. My show has been geared toward finding ways to get access to affordable quality medical care. Let's transpose that to the legal system. How do we go about getting access to quality, affordable legal counseling? Because I think that the legal system is probably even more inefficient than the medical system in our country. I mean, is that a...
You stated before, by the way, doctor, there's one thing that John and I have learned over the years as experienced malpractice lawyers. We both know that medicine is very difficult. Tough decisions are made, and we both respect the medical profession. But the medical profession has to understand, too, that there are doctors that commit negligence. And I'm not talking about just the incompetent physicians. I'm talking about reasonably prudent doctors who are out there and have a bad day at times. And the philosophy of the law is that if there is a deviation of the standard of care and the person is injured, they should be compensated. We don't work by the hour. We don't get $250 an hour like a corporation lawyer. John and I work on a contingency fee contract, and our fee is fixed by law. And so, you know, a contingency fee contract is that if we win or lose, that is going to determine whether or not we earn money for that particular case. And the old joke is when they come in for a contingency fee contract, you look at the client and you say, if we lose, I don't get anything. And if we win, you don't get anything. You see, so it works out that way. But we put up the costs. We front the costs. You get a doctor who's objective and who's good to review a case. They charge us $500 an hour. Some doctors want a retainer of $2,000 to review a case. But that's the kind of money that you have to spend to determine if the case has merit, because these cases are tough and they're time-consuming. So we try to get the best doctors. And John and I will spend at times $3,000, $4,000. In a baby case, you get a neonatologist, you get a pediatric neurologist, you get an obstetrician, and there may not be a case. So that client, through us, whether he's poor or rich, has an opportunity to go into court and to bring a suit if the suit has merit. So from a contingency fee contract, the law is there for the average person. But if the lawyer charges by the hour, I mean, even doctors can't afford the lawyer at times.
Well, but I wonder, given what the doctors charge me to consult on cases, whether it's to review a case for merit or to review the ongoing discovery to see if they might want to testify as an expert. I mean, $500 an hour is average, $750. I mean, you know, either one, who do the doctors think they are, or two, is it that kind of economic logic that translates into our country having, what, the 10th best health care in the world and the most expensive by 3 times of anybody else's? I mean, the doctors are not hurting financially in the medical legal situation, and they're making it more difficult, because if you can imagine a new practitioner who's a lawyer, whose neighbor comes over with a medical malpractice case and said, could you please review this? He doesn't know who to call, but what he's going to soon discover is when he begins calling the doctors to review it, I mean, they want to do an assets check on the guy first to see what he's worth.
Well, obviously, John and Norm are overpaying doctors for reviewing cases. I know you are, because I have worked with attorneys to get them experts to review cases for a heck of a lot less.
That's different.
I'm not talking about even in psychiatry. I'm talking about orthopedic surgery. I'm talking about radiology. You're obviously paying a premium, so I hope you're getting your money's worth. But the fact of the matter is, going back to the suggestion you made, Dave, with regards to certifying attorneys, perhaps really what we ought to do is certify physicians to review medical malpractice cases rather than attorneys.
Good idea.
In Colorado and several other states, that's part of the tort reform statute. An attorney cannot bring a medical malpractice case unless it has been reviewed by a specialist in the same field of the defendant that is being sued.
That's a good idea. You know,
That's the way Nevada works, too.
and they do that in the workers' compensation area. They have certified physicians to do that. That's a very good idea.
But I do think you're overpaying your experts. I'm sorry. I hope I don't offend your experts.
Poison
experts. I'm going to talk to you right after the show.
Actually, what is paradoxical about our system is that we have a situation of collective responsibility. In other words, you may have a few bad apples in terms of doctors, negligent. I don't think there are that many. I mean, as far as I know, the great majority of the physicians I know of are good physicians, very conscientious, well-trained, practice good medicine. We're talking about a few cases that spread the responsibility to everybody else. And actually, there's a situation in San Jose in the last 10 years or so. A colleague of mine, Dr. Harvey Canuncio, has been instrumental in instituting a system whereby, by peer review and by selecting the physicians carefully to belong to a group of malpractice liability insurance, they have cut down tremendously on the problem of malpractice. In other words, I agree that we as physicians have to have a way to get a hold of those physicians who are grossly negligent.
I mean, most doctors are capitalists. They're into the free market of medicine. They make very, very good money. But let's assume you, being one of them, take your money to a investment advisor, a banker, a stockbroker, and that person, through an off-day negligence, loses. Let's say you've given them $750,000 to invest. I mean, what I'm hearing from you is doctors shouldn't be sued. But yet, if your child was run over by a policeman, let's say, who was inebriated or something, you'd want to be able to...
I never said that doctors shouldn't be sued. I never said that at all. I'm saying that a few doctors who are negligent and incompetent spill over the situation, and everybody else has to take the responsibility of what they did.
But I'm confused by what you're really saying. On the one hand, you're saying that, gee, all of your friends now, they're really afraid to practice medicine. Isn't it really just a few bad apples? It's more, I think, what Norm and Dr. Rubseman were saying, that anybody can make a mistake which is negligent, which can harm somebody else. And then you have to make up your mind. Who do you want to protect?
Well, it's impossible under the current atmosphere of high tech and all the things. It's hard. I mean, you cannot have perfect results. And I feel that the high expectations of an American patient sometimes is impossible to meet.
Well, that's what leads to the number of suits, Dr. Vu. There's no question about it. The number of suits is reflected in that high expectation. But realize that a very substantial portion of those suits, and I think it's over 50%, would not be brought by the best malpractice attorneys. So we're talking about two different things. We're talking about, on the one hand, the number of unnecessary suits, which causes a tremendous amount of mental anguish and suffering on the part of doctors, which I think is unjustified, which does lead to the sort of unreasonable defensive medicine that Dr. Firestone was talking about. And on the other hand, you have malpractice, you have negligent conduct by a doctor who may be perfectly adequate normally, and we have to make up our mind, as John says, whether we're going to compensate that or not. Now, there are some states in the United States where that is not compensated, even today, because nobody will testify against that doctor. If they find someone from outside the area who will come in and testify, the juries won't listen to him. And I could identify a couple of counties in California, which in the history of man have never compensated an injured plaintiff. So that it is such a thing as a social attitude in certain areas. Sometimes it's just in a county, sometimes in a whole state, so that people don't get compensated. But you have to make up your mind whether in our system we're going to adhere to this theory that negligent injury should be compensated. And I do emphasize, contrary to the opinion of many doctors, the great majority of the time, there has to be reasonably clear negligence, or the jury is not going to come in favor of the injured party. Now, it's hard to find a doctor who loses a case who thinks that it was a justified result. And that may account for much of the propaganda against my opinion. But as one who works with doctors, sympathizes with them, writes for them, I have to say that if we adhere to this system, that's the way it's going to be. Now, I advocate adjusting the system, certification of malpractice attorneys, doing away with jury trials, going to a more private system, either arbitration or my preference would be specialty judges, judges who are really familiar with medicine, who get to know who the experts are for each side. So if an expert keeps showing up again and again for the plaintiff, he becomes a little more skeptical. And the same can be said, the same expert keeps showing up again and again for the defense. And I think this would be a better system, especially if it could be kept in a more private way and if it could be made expeditious. I think those would be excellent reforms.
Actually, I'm surprised to hear from you that the jury has sympathy for the doctors too. I mean, it seems to me that most of the time what I have read or heard is that you have a baby who's maimed or a person who loses a limb, the jury goes all the way for him.
Yeah.
Against the doctor.
Yeah, this is a common mythology. You talk to any really experienced person in this field who is objective, and they'll tell you that in general now, if the doctor has not altered his records, if the doctor has not been caught in some outright lie, which I trust would be very rare, but has happened, if the doctor seems like, you know, a reasonable person and isn't attacking everybody from the witness stand and challenging the plaintiff's attorney, how could you possibly sue me, etc. In those circumstances, the outlook may be bad for the doctor. But in general, the juries do favor doctors. They want to believe the doctors. And I could, if you read, for example, the plaintiff's confidential report on jury verdicts, comes out every 2 weeks. If you read that for a couple of years, you would read case after case in there where you'd say, gee, that doctor was lucky. The jury came in for the defense, came in the doctor's favor, the hospital's favor. This is reality. And if you think of all the cases which come in for the plaintiff where you say to yourself, gee, that's not really a fair result. And you think of all the cases that came in for the defense, and you say to yourself, gee, they were pretty lucky. There's a lot more of the latter than the former. Do you think that's true, Marv, John?
I have to agree with you wholeheartedly. I've polled jurors after cases, and there's no question that even though the jury in a medical malpractice case is told that they must find for the plaintiff by a preponderance of the evidence, jurors hear that almost as a charge to find that the defendant was liable beyond a reasonable doubt. Jurors frequently say, well, you'll ask them, why did you find for the defendant in this case? Well, he, I think, was a good doctor, and he didn't mean to hurt the patient.
Did the best he could.
Yes, and they, even though they're told differently by the judge.
Let me give you a good illustration, Dr. Booth, a little anecdote that may fill in here and tell you a lot. There was a case that a friend of mine tried involving a man who had a delayed diagnosis of an osteomyelitis of the tibia. It occurred around a screw that had been put in 15 years earlier, an old fracture to fix the bone, and somehow some bacteria in his bloodstream had gotten lodged there and started this infection. So he had a osteomyelitis. He went to a doctor, about 2 different doctors, about 6 or 8 times, complaining of pain. The doctors, believe it or not, never took off and had him take off his pants to examine that leg. The first doctor said, it's in your knee, it's referred pain, I'm going to give you some non-steroidal anti-inflammatory agent for it. That's the way he was treated for several weeks. When it finally got really bad, he went to an emergency room. The doctor did an appropriate examination. He had a huge infection. The bone was excavated to get rid of the infection, and the infection was gotten rid of, and the leg was saved. Now, this man was a truck driver, and he was a behemoth. He had tibias that were 3 times normal size. The excavation, which was that deep, was still not enough to really weaken that tibia. And this was a very tough guy and very negligent treatment.
How
and
often
after
does this situation happen, though?
Not uncommonly. After the defense verdict, they asked the jury, and the jury said, oh, come on, this guy's tough, he's big, he was treated badly, that's no doubt, but why blacken the doctor's record? Now, this is a case where midway through trial, a very tough defense attorney offered $55,000 in settlement because he thought there was no chance of his winning the case. And the plaintiff's attorney offered it to the client, and the client said, nope, I want that jury, I'm a red-blooded American, I want the jury to say it. If they come in for me, fine. If they don't, that's okay. He was that kind of a guy. And that sort of result, where you have an injury without significant residual disability, because for a big tough guy, an ugly tibia is no disability. I mean, he wasn't a Marilyn Monroe, you know. So the rule is, a rule of thumb, if you have a significant injury, but with complete recovery, even though there may be some harrowing aspects to it, as the pain this man suffered, that is not a very good case, because juries again and again and again will come in for the defense on cases like that. Am I right, Norman?
Absolutely. Usually the errors are simple. An anesthesiologist, epidural anesthetic, knows you can get into the subarachnoid space, so they have to monitor the vital signs for a certain period of time. The anesthesiologist leaves the patient at that point, goes and listens to the Giants game, comes back, the patient is cyanotic. Well, that's a true story, okay? I mean, that's the kind of a case. It's a simple error, and that's the kind of a case where you're going to get a big verdict. But David is right, and Marvin is right. 2 out of 3 cases are lost if the case goes to trial. And, you know, there was a defense attorney once, his name was Joe Rankin, great attorney, and it was a very famous case in California, Quintal. He was an ophthalmologist. His patient, young boy, had a cardiac arrest on the table. The ophthalmologist left the room, and that was a big error. Rankin told me, look, if he had just rubbed the soles of that boy's feet, he says, I could have got him off. And he was right, because the jury, you know, they don't hold you up to this big standard. They just say, did he do his best? Did he care about the patient? Okay. And mostly, did he do his best?
Okay, we're sort of running out of time. Ladies and gentlemen, you just heard from our expert panelists sharing with us their views and experiences on a very important subject, that is medicine and the law. And you also have with us here a few selective and thoughtful guests in our audience. Some of them just couldn't make it to be in the show tonight. On behalf of the viewers who will enjoy this show, I'd like to express my warm and sincere thanks for all of you for being here tonight. The fact that we could come here at the end of a hard working day on a voluntary basis has a very special meaning to me. And I feel that this kind of honest and open communication will contribute in minimizing a lot of unnecessary problems in our healthcare delivery system. If you'd like to be invited to our show, please call 415-328-3429 for seat reservation. And for the schedule of our next productions, time and dates, please consult your listing in your local newspapers. Again, I'm Dr. Hung Vu. Thank you for watching. Good night.